I was especially excited to be invited to give a keynote talk at this conference alongside Gary Francione, because almost 10 years ago, I myself co-organized a conference in Basel where Gary Francione was the keynote speaker. The topic back then was animal law, reform or revolution, and of course Gary was invited to vigorously defend the revolutionary animal rights position against the reformist welfarist position. So my talk today will actually pick up on this dichotomy between welfare and rights, or between reformism and abolitionism, and I seek to present an alternative complementarity approach. It is thus quite fitting that the two other keynote speakers at this conference are somewhat representative of these two poles of this dichotomy. So we have Gary Francione, who is basically the father or grandfather by now and one of the staunchest defenders of the abolitionist animal rights position. And David Faber, on the other side, is a well-known defender of a more moderate welfarist position, even though his talk now indicates, or tomorrow indicates, that maybe he's moving towards an animal rights position as well. So the position I'm going to defend today is a bit more complicated than either welfare or rights. Rather, in a somewhat dialectical fashion, my approach seeks to reconcile both approaches, or both traditional welfare and rights approaches. So my goal will be to reconfigure the traditionally dichotomized relationship between animal welfare law and animal rights as one of complementarity rather than mutual incompatibility, and in doing so to allow for both animal welfare law and animal rights to play a constitutive role in the construction of animal law. So, my starting point is based on two observations about the current or traditional landscape of animal law. First, the normative inadequacy of existing animal protection law, on the one hand, and on the other hand, the discursive impasse generated by the welfare rights dualism. So animal protection is today a generally accepted moral and political objective, and it is also solidifying globally as a legal concern. And I use animal protection here as an umbrella term for any kind of protection for animals, including welfare or rights. However, the legal protection has traditionally been monopolized by animal welfare law, which continues to be the designated and mostly the only designated body of law that is charged with fulfilling this animal protective mandate. Contemporary animal protection law, while not synonymous with animal welfare law, is thus largely coextensive with animal welfare law. And this is problematic because animal welfare law is but a deeply imperfect legal regime that falls gravely short of realizing its eponymous purpose to protect animals, as evidenced by the billions of animals suffering in factory farms, slaughterhouses, or laboratories. So while virtually all animal lawyers agree that the current state of animal protection is gravely inadequate, they strongly disagree about how best to reform animal protection law. And this question continues to be debated within the dualistic welfare rights framework for the most part. Broadly speaking, the welfare approach, which informs existing animal welfare law, holds that humans are entitled to use and kill animals for numerous purposes, but in doing so, we should treat animals humanely and avoid inflicting unnecessary suffering. So under the welfare paradigm, human use of animals isn't generally disallowed, but the instrumental violence it inevitably entails is moderated through regulation. By contrast, the rights approach holds that animals are the bearers of inviolable rights, which protect them from being sacrificed or harmed for human utility. The animal rights approach is typically coextensive with an abolitionist position in that it opposes harmful animal use altogether and thus ultimately requires at least the abolition of institutionalized animal exploitation. But there is some gray area there between the Francione extinctionist abolitionist view, as Sue Donaldson and Will Kimlicka put it, and maybe more abolitionist light views about how humans and animals can still have basically benevolent or nonviolent relationships. So I'm putting that discrepancy aside here. But so given the differing objectives regulation versus abolition of animal exploitation, the welfare and rights paradigms have traditionally been cast as mutually exclusive and opposing paradigms for the legal protection of animals. As Joyce Tischler has noted, this dichotomy between rights and welfare, or between abolition and regulation, was present from the inception of animal law. And historically, this probably makes sense, given that the animal rights position was formulated mostly as a critique of and advanced as a better alternative to animal welfare law, which was and is quite insufficient. So, but for the purposes of contemporary animal law, I think this, and others think that too, that this rigid dichotomy between welfare and rights has become increasingly problematic and unproductive. For one thing, as Jessica Eisen has noted, the welfare-rights dichotomy has made for an increasingly stale and stagnant debate, much of which revolves around defending one position and discarding the other. Moreover, the ostensible either-or choice between animal welfare law and animal rights is unsatisfying and has led to a stalemate because both approaches suffer from flaws. On the one hand, animal welfare law has been abundantly criticized for being, at best, largely ineffective in achieving any significant improvements for animals, or at worst, for being counterproductive in that it stabilizes the underlying system of animal exploitation. On the other hand, the animal rights approach is widely discarded as utopian and impracticable, as it aims for unattainable goals whose achievement are unrealistic at present. Indeed, animal rights proponents are often charged with engaging in some kind of ideological fundamentalism by prioritizing an idealistic future agenda over tangible reforms that would help animals who live and suffer right now. So in short, with pragmatic animal welfare law being too unambitious and compromising to offer sufficient legal protection for animals, and idealistic animal rights being too ambitious and uncompromising to offer a politically feasible alternative, we are faced with the dilemma of an untenable status quo and no palatable solutions for reforming animal protective law in a manner that is not too peripheral and thus not meaningful enough, or too radical and thus not realistic enough. I'm not the first one to note this dilemma and to articulate the need for moving beyond the welfare rights impasse. For example, Jessica Eisen in her article Beyond Rights and Welfare, and Will Kimlicka in his article Animal Law Beyond the Property Personhood Impasse have explored alternative routes for animal law reform beyond the welfare rights dualism. What I propose is not so much to discard the welfare rights dualism per se, but rather to diffuse the welfare rights dichotomy and to reframe it as a welfare rights complementarity. That is, instead of opting for either animal welfare law or animal rights, I propose a complementarity-based framework for animal law in which animal welfare law and animal rights can have a meaningful coexistence. I call this the complementarity approach. So in a nutshell, the complementarity approach submits that animal welfare law and animal rights are best understood not as mutually exclusive paradigms for the legal protection of animals, but rather as distinct yet complementary legal regimes that both share a basic commitment to animal protection and each govern different contexts and serve different functions. And the way, now it gets complicated, the way I arrive at this complementarity between animal welfare law and animal rights is by drawing an analogy with the international law of war and peace. In this analogy, animal welfare law functions as a kind of wartime regime akin to international humanitarian law, and animal rights functions as a peacetime regime akin to human rights. But what does war have to do with this? And why bother with this seemingly far-fetched comparison between animal law and the law of war and peace? So generally speaking, legal comparison is used to gain a better understanding of problems faced in one's own area of law and to find better solutions to those problems. And in the case of animal law, the key problem, as encapsulated in the welfare rights dualism, is the intractable conflict between regulating and or preventing institutionalized violence against animals. And in this respect, the law of war faces quite a similar conundrum, notably the simultaneous prohibition and regulation of war, or the paradox of permitting the impermissible. On the one hand, both international humanitarian law, which from now on I'm going to abbreviate as IHL, so both IHL and animal welfare law are marked by the fundamental aporia of humanizing the inhumane. Indeed, there exists hardly any other modern body of law that has as its object not the abolition and prohibition of violence, but rather the regulation and governance of extreme and lethal collective violence. At the same time, however, and unlike animal welfare law, IHL is complemented by a law of peace. And this law of peace seeks to prevent the very violence of war in the first place and governs the protection of humans in times of peace, notably through human rights. So I believe it is this simultaneousness of both regulating and preventing the violence of war and of protecting people in both wartime and peacetime, which animal law stands to learn from the international laws of war and peace. So the comparison with international humanitarian law and human rights, which have historically also been dichotomized legal regimes and have only gradually been understood as complementary legal regimes. So I think the comparison with these two regimes unlocks the potential of complementarity for the traditionally dichotomized relationship between animal welfare law and animal rights, and can serve as a model for restructuring animal law into an animal law of war and peace, which I've kind of tried to show on this slide here, and I will further explain in the course of this talk. So based on this comparison, I propose to reconstruct animal welfare law as a pragmatic wartime regime that governs violent human-animal relations, the so-called war on animals, and animal rights as an aspirational peacetime regime that governs harmonious, peaceful human-animal relations. And I do so at length in my paper, but for the remainder of this talk, I will focus on substantiating the somewhat curious notion of animal welfare law as a warfare law, and will then only briefly highlight the complementarity with the animal law of peace. Okay, so my basic claim is thus that animal welfare law functions like a warfare law that governs violent activities within a ubiquitous war on animals. But what exactly do I mean by saying that animal welfare law functions like a warfare law? In what regards is the regulatory regime of animal welfare law comparable or similar to the one regulating actual war and warfare? So there's several aspects in which these regimes are similar, which I will go through briefly now. So first, in terms of the object of regulation, both animal welfare law and IHL govern an inherently violent institution. IHL is, of course, the body of law that regulates armed conflict or war and the conduct of warfare. Animal welfare law, on the other hand, on a literal and ahistorical reading, might be misunderstood as the body of law governing human-animal relations and regulating them in a manner that ensures animal welfare. But in fact, quite the reverse is true, because contemporary human-animal relations are framed by an overall exploitative context that is a priori premised on the usability and disposability of animals. The actual object of regulation, as received by animal welfare law, is animal exploitation, or, if you will, animal welfare as a secondary function of animal exploitation. Both war and animal exploitation involve large-scale violent activities, and both are constituted by a distinctive kind of violence that is of an inherent, instrumental, collective, and institutionalized nature. Numerous commentators have likened animal exploitation, the institutionalized violence it invariably comprises, and the animal-industrial complex sustaining it, to war. Most notably, Dinesh Vadivel argues that our systems of violence towards animals precisely constitute an actual war against animals. And while I don't necessarily agree with the notion that humanity is waging a literal war on animals, I do use the term war on animals in a figurative sense to describe the inherently violent character of animal exploitation and thus the object of regulation of animal welfare law. So in this figurative sense, animal welfare law governs the war on animals. Secondly, in terms of the historical formation, both animal welfare law and IHL have emerged in reaction to the pre-existing violent institutions of war and animal exploitation. The modern codification of both bodies of law in the 19th and 20th century was driven by similar material and social conditions, notably the exacerbating violence associated with modernized and industrialized warfare and animal use practices on the one hand, and on the other hand, by advanced humanitarian or humane sensitivities. Moreover, both animal welfare law and IHL originated in a historical context when war and animal exploitation were accepted as a given, and accordingly, both bodies of law simply presupposed the legitimacy or factual existence of these institutions. This means that IHL and animal welfare law are not abolitionist in nature. Neither aims at prohibiting the very institution that is foundational for the respective body of law. Rather, both animal welfare law and IHL are regulationist in that they simply receive the violent institution as a fact and proceed to regulate and restrain it. In both cases, the regulatory rationale for this normative intervention is the humanization, not the elimination of violence. So both IHL and animal welfare law are thus marked by a tension between two antithetical forces. On the one hand, the accepted reality of war and animal exploitation and the instrumental violence they necessarily involve, and on the other hand, countervailing considerations of humaneness. The law of war seeks to balance these two antithetical forces of military necessity and humanitarian considerations, and seeks to minimize human suffering without undermining the effectiveness of military operations, which is paradigmatically expressed in the preamble of the Hague Convention, which I've put on this slide. And interestingly, we find very similar language in animal welfare law. I've put an example of the Swiss Animal Welfare Act here, which seeks to ensure the welfare of animals as far as the intended purpose permits. So animal welfare law seeks to balance the necessities of animal use on the one hand and conflicting humane considerations, and the principal objective is to mitigate animal suffering while preserving their economic use. So overall, both IHL and animal welfare law seek to strike a balance between these conflicting objectives, and neither body of law will ever exclusively serve one purpose over the other. So the laws endeavor to reconcile both the necessity and humanization of violence is most clearly expressed in the principle of unnecessary suffering, which is a fundamental principle in both IHL and animal welfare law. The rule prohibiting unnecessary suffering and allowing necessary suffering, e contrario, requires a proportionate balance between the necessity or utility of violence and the harm caused, and thus a kind of means-end proportionality. And it is worth noting that in both cases, this necessity test does not extend to the evaluation of the ends themselves. So military objectives and animal use are simply posited as legitimate purposes. The necessity test is thus limited to an assessment of the instrumental necessity, which only measures whether an act is necessary to achieve a given animal use objective, which may be and often is unnecessary per se. Gary Francione and Anna Charlton have rightly noted in this context that what is actually measured is thus the necessity of unnecessary suffering, and thus the legal notion of unnecessary suffering merely captures unnecessary suffering. Finally, due to this ambivalent configuration of IHL and animal welfare law, both bodies of law have attracted very similar criticisms alluding to the dark side of humanization. Notably, that the legal regulation of violence not only serves to humanize, but also to legitimize and reinforce the violent institutions of war and animal exploitation. Critical voices highlight that IHL and animal welfare law essentially establish an extremely violence-permissive legal regime under the guise of humanization. This creates what has been called the humanitarian myth and the humane myth, so the mistaken belief that legal warfare and legal animal use practices are humanitarian and humane practices. Myths that are best encapsulated in such oxymorons like the humane war and humane slaughter. So all things considered, both IHL and animal welfare law thus perpetuate a somewhat paradoxical and reactive dynamic of imperfectly humanizing while simultaneously facilitating and consolidating the very institutions that are the cause of the suffering they aim to mitigate and that render humans and animals in need of such like protections in the first place. So, seeing that animal welfare law shows some of the main hallmarks of the law of war, I submit that animal welfare law is best understood as a kind of warfare law that regulates violent activities within the ongoing war on animals. To briefly recap, this animal warfare law is marked by the following characteristics. It regulates the factually pre-existing and normatively presupposed inherently violent and inhumane institution of animal exploitation. In doing so, it seeks to restrain rather than prohibit collective violence against animals and to mitigate rather than eliminate the suffering caused. It is shaped by the diametrically opposed considerations of humaneness and non-humane instrumentality and continuously negotiates and redefines the permissibility of violence associated with animal use practices by prohibiting unnecessary suffering while concomitantly permitting, legitimizing, and reinforcing the residual necessary violence. But what is the purpose of redescribing contemporary animal welfare law as an animal warfare law? I believe that reframing animal welfare law as a warfare law furnishes a refined and more realistic understanding of the ambivalent and violent nature, the pragmatic function, and the inherent limits of animal welfare law. So by its very nature, animal welfare law operates in ambivalent, both violence permissive and violence repressive or restrictive ways. It is as much about ensuring minimum standards of welfare for animals as it is about facilitating warfare or efficient warfare against animals. Placing animal welfare law in conceptual proximity to IHL clearly dispels widely held humane myths about animal welfare law, such as exaggerated humane expectations or the unwarranted overemphasis of its humane achievements. Rather than being the pinnacle of humanization or civilization, animal welfare law actually governs the worst kind of human behaviors toward animals. And it is a legal regime most akin to the law of war, which precisely governs basically the breakdown of human civilization. Moreover, reframing animal welfare law as a warfare law acutely spotlights the sheer scale and intensity of violence that is allowed by animal warfare law. Whereas IHL is fundamentally based on a distinction between combatants and civilians and designates combatants as the only lawful or legitimate target for intentional violence, a comparable principle of distinction is lacking in animal welfare law. All animals are the lawful targets of instrumental violence. And it's worth pausing over this disparity because it means that animal welfare law indiscriminately exposes passive, harmless animals to the same quality of violence that IHL firmly reserves for combatants who are actively engaged in armed hostilities. Put differently, the law essentially treats animals or exploited animals as quasi-combatants. However, the demystification of animal welfare law as a warfare law does not need to delegitimize animal welfare law altogether. Contrary to the assertions of some critics like Gary Francione, animal welfare law is not wholly inutile or dispensable. Rather, the comparison with international humanitarian law provides a pragmatic defense of animal welfare law as an ugly but necessary wartime regime. So as long as war and animal exploitation remain an ugly social reality, legal regulation seems necessary in order to provide at least some relief to its victims. Both IHL and animal warfare law are set against the factual backdrop of worst-case scenarios pre-existing in slaughterhouses and on the battlefields. So given this distressing point of departure, animal welfare law and IHL adopt a pragmatic, something is better than nothing approach that seeks to salvage what can realistically be protected. At the same time, however, we must also be cognizant of the inherent limitations inscribed into the very fabric of animal welfare law as a warfare law. Despite its humane ethos, both IHL and animal warfare law remain a law about killing and injuring humans and animals, albeit in a civilized sort of way. Indeed, given the violent nature of the activities these norms seek to regulate, and the hostile environment in which they operate, the parameters for humanization are very narrow. In both cases, their function is limited to marginally humanizing a profoundly inhumane institution. Moreover, since IHL and animal welfare law are not only foundationally agnostic toward a violent institution, but are existentially contingent on a violent institution, neither can and neither aspires to address or repress the causes of the violence they seek to regulate. As Henry Shue has vividly put it in the context of war, this is a quote, the prevention of wars is a morally urgent task, but it is not the task of the laws of war. The purpose of the laws of war is to constrain the shit when the shit happens, end quote. So this means while preventing the war on animals is a morally urgent task, it is not the task of animal warfare law. The purpose of animal welfare warfare law is to provide protection within, but not from or beyond the war on animals. In order to prevent rather than merely regulate the war on animals, we need to look beyond animal warfare law to an animal law of peace. So, at this juncture, the comparison with the law of war actually points to a significant normative vacuum in the current composition of animal law. It misses a law of peace. This marks a crucial difference between IHL and animal welfare law. From the outset, IHL is designed as an exceptional regime that is only applicable in war and that is counterbalanced by an ordinary law of peace. Notably, the jus contra bellum, so the prohibition of the use of force which generally outlaws war, and human rights, which are the primary human protective regime in times of peace. By contrast, because the war on animals is the ubiquitous norm rather than an exception, the law regulating it is not an exceptional, but rather the default or only animal protective regime. That is, while IHL is embedded in international law's explicit understanding that peace and the law of peace is the norm, and war and the law of war is the exception, animal law is constructed on the implicit assumption that the war on animals is the normal and ever-present condition. Therefore, any analogical distinction between a state of war and peace is unknown to animal law. For animals, to put it in Orwellian terms, war is peace. Animal warfare law is thus easily mistaken for an ordinary law of peace because the war on animals has yet to be exceptionalized and a proper peacetime regime has yet to form. So repositioning animal welfare law as a warfare law thus accentuates the need for constructing a counterbalancing animal law of peace and creates space, mental space, discursive space, I guess, for thinking about what such an animal law of peace could look like. In analogy to the law of war and peace, I propose two main components of such an animal law of peace, a kind of jus contra bellum for animals, I call this a jus animalis contra bellum, and peacetime animal rights. And for lack of time, I will now only briefly outline these two additional animal protective regimes and highlight their complementarity and interplay with animal welfare law. So for the first animal protective regime, the jus animalis contra bellum, this is in analogy to the human jus contra bellum, which determines the legality or illegality and legitimacy of wars. So animal law needs to be complemented with this kind of jus contra bellum that works to prevent the war on animals in the first place, and that provides a mandate to build and maintain peace with animals. So this body of law would determine the legality or illegality of the war or of instances of the war against animals. In an analogy to the jus ad bellum or jus contra bellum, as enshrined in the UN Charter, we may call this the jus ad exploitation or jus contra exploitation. It may incrementally outlaw certain forms of animal exploitation and may eventually stipulate a general prohibition of institutionalized animal exploitation or collective violence against animals, while simultaneously carving out legitimate exceptions that justify resort to collective violence against animals, such as self-defense or existential necessity. However, even a strict jus contra bellum will likely not succeed in completely eradicating the factual reality of animal exploitation. This is abundantly clear in the case of human wars. Be they legal or illegal, they continue to exist despite the UN Charter's prohibition. So to the extent that the factual reality of animal exploitation continues to persist, albeit maybe in a lesser, an exceptionalized form, animal welfare law will continue to be applicable in such violent wartime situations. To the extent, however, that the jus contra bellum succeeds in preventing instances of the war on animals and creating instances of peace with animals, it paves the way for the formation of a more aspirational animal law of peace. And just as human rights are at the core of the human protective law of peace, I propose that animal rights should be the primary peacetime regime protecting animals in peaceful situations. So what do I mean by peacetime? If peace is the absence of war, peacetime for animals would mean the absence of exploitative, violence-based human-animal relations, and conversely, the presence, or at least aspiration, of non-exploitative, non-violent, justice-based human-animal relations. Peaceful human-animal relations, such as cooperation or friendships, would notably be based on regard for the life and intrinsic value and the own interests and well-being of animals, rather than on mere instrumental interests in animals, and would generally require humans to abstain from harmful animal use practices. So as designated wartime regime, animal welfare law is not applicable in peacetime. By the same token, fundamental animal rights, such as the right to life, bodily integrity, and freedom from torture, are squarely incompatible with animal exploitation. Put differently, animal rights, much like human rights, are fundamentally hostile to war, and war is their quintessential negation. Because animal rights are conditioned on peacetime, and they are either entirely inapplicable in wartime, or they need to be watered down significantly to make their application in wartime conditions intelligible. So in this sense, animal rights and animal warfare law are dichotomous, just as the states of war and peace are dichotomous. Animal rights are designed for governing peacetime situations, and animal welfare law is designed for governing wartime situations, which is why animal rights are as conceptually ill-suited to manage the ugly reality of war as animal welfare law is incapable of transcending it. This is, however, precisely why we need the complementarity of both legal regimes, in order to operationalize a more concerted legal protection of animals in, from, and beyond war. As designated wartime and peacetime regimes, animal welfare law and animal rights serve different and somewhat incompatible functions that cannot easily be replaced by the other. So to conclude then, I want to briefly highlight the benefits of the complementarity approach vis-à-vis the traditional welfare rights dichotomy. First, thinking in terms of complementarity rather than dichotomy allows us to diffuse two persistent concerns voiced on both sides of the welfare rights debate. On the one hand, and while my analysis is definitely not intended as an apologetic of animal welfare law, it does dismantle the frequently held view that animal welfare law is useless or a mere tool in the service of exploiting animals. Reframing animal welfare law as a warfare law certainly strips it of its humane glitter, but it also somewhat rehabilitates the legitimacy of animal welfare law as an ugly but necessary wartime regime. On the other side, animal rights have so far been unable to shake off the stigma of quixotic idealism. By reframing animal rights as a peacetime regime, this idealism can be reclaimed and asserted as a necessary component of an aspirational animal law of peace. And furthermore, understanding animal rights as complementary rather than as an outright alternative to animal welfare law makes their legal institutionalization more palatable. So in terms of overcoming the discursive impasse of the welfare rights dualism, my hope is that the complementarity approach may convince both animal welfare proponents of the added value of instituting idealistic animal rights and animal rights proponents of the factual necessity of retaining pragmatic animal welfare regulation. Moreover, the complementarity approach also offers a more practicable blueprint for the dynamic development of animal law on the ground. Indeed, in view of the recent emergence of judicially recognized animal rights, the envisioned scenario in which the legal protection of animals is dually governed by both animal welfare law and animal rights seems to be already unfolding in practice. The complementarity approach offers a plausible explanation for this legal development. Complementarity precisely means that despite the existence of animal welfare law and despite the persistence of animal exploitation, animal rights can develop in parallel as an additional, more ambitious layer of animal protection law. In terms of reform, I thus project that animal law will develop in a manner that echoes the development of IHL and human rights, one in which animal welfare law and animal rights coexist and co-evolve side by side, since both continue to address different realities and serve different functions. Whereas the first generation of animal law scholarship was shaped by the great divide between welfare and rights, perhaps it is now time to let go of this rigid and perhaps somewhat simplistic dualism and move forward. And I believe the complementarity approach offers a more nuanced, both ambitious and realistic model for the future of animal law, one in which both pragmatic animal welfare law and idealistic animal rights have their place. But with all that said, I do want to stress that the focus of animal law reform should, of course, be on developing and strengthening the animal law of peace, so that, one day, hopefully the war on animals will be a thing of the past and humanizing the inhumane will no longer be necessary. Thank you.